Hello and good afternoon. I would like to welcome everyone to the final Envoy webinar of April, From Employment-Based Visa to Citizenship, a look at how foreign workers can become U.S. citizens. We have a great presentation ahead of us for the next 45 minutes, but first a reminder that today's session is being recorded, and we will send a link to download the recording after this afternoon's live session. We also encourage you to ask some questions throughout the presentation. To do so, please ask a question using the GoToWebinar control box that you see on the right-hand side of your screen, and we'll try to get to those questions either throughout or at the conclusion of the main presentation. All right, so for nearly 20 years, Envoy has been on a mission to fix the inefficient, frustrating, and confusing immigration process. Envoy combines expert legal representation with innovative technology to deliver the only platform that makes it seamless for companies to hire, manage, and mobilize a global workforce. Envoy secures work authorization in 150 plus countries, has grown 46% year to date, and works with over 1,000 customers. We are particularly proud of our NPS score, which is a testament to the employee experience that we provide. And with the intro and about Envoy out of the way, I would like to introduce today's main presenter, Ann Walsh. Ann is a managing attorney with Global Immigration Associates. Her practice includes providing counsel for companies ranging from startups to Fortune 500 corporations and their foreign national employees on obtaining visas and employment-based green cards in all categories. Immigration compliance arising from corporate changes, such as reorganizations, restructuring, and office relocations, and company immigration policies and best practices. And has extensive experience preparing and reviewing business immigration filings, requests for further evidence and appeals, and in researching and analyzing immigration statutes, policy, and procedure. In addition to her employment-based practice, Ann provides counsel for individuals pursuing visas and green cards through family relationships and has earned distinguished merit for her pro bono work. Ann, so excited to have you this afternoon.
Thank you. Happy to be here.
Great. So before we jump into the meat of the presentation, just want to provide our attendees a quick agenda. So this webinar will walk you through the various stages of the citizenship process, from hiring a worker on an employment-based visa to the green card, and then U.S. citizenship through naturalization. All right, so without further ado, let's jump into things. Starting with our first section, despite government scrutiny, the demand for foreign talent remains high in the U.S. If you're able to join us, a couple of weeks ago, we recently ran a webinar on requests for evidence, and we looked at some data for USCIS and examined how over the last couple of fiscal years that the rate of requests for evidence has increased. Despite that, though, as we see on this slide, that the demand for foreign talent remains high. And we further found that in our 2019 Immigration Trends Report, nearly 80% of companies expect foreign national headcount to increase this year. While this is a decline from 2018, it still shows that companies are looking for foreign talent to fill their key job openings. Additionally, and as we see here, sourcing foreign national employees for a talent acquisition strategy is important for many companies. Additionally, as we found out, 95% of companies said sourcing foreign national employees is somewhat, very, or extremely important. And the reason I show these two slides because it brings me to this following slide here, where a few headlines in recent months showcasing the U.S. Labor shortage and the impact it's having. So we take a look at the top left. The U.S. labor shortage is reaching a critical point. America's $103 billion home health care systems in crisis as worker shortage worsens. And the New York Times recently ran an article, Short of Workers, U.S. builders and farmers crave more immigrants. So sourcing foreign talent to fill open jobs not only helps the company, But it can also help a foreign national's life by enabling him or her to move to the U.S. to make a living and, if he or she chooses, become a U.S. citizen. So, Anne, this is where I'm going to loop you in. Let's start with the first part of that journey, hiring a worker. So, Anne, let's say I'm running a business and I need to hire I need to hire talent. Where do I start?
Sure. So if you identify a talent need and a foreign worker to fill it, you will then need to assess and pursue the type of visa that you can sponsor this individual for. So you'll see on the slide a few common options. To start, the H-1B visa. If you do have a active foreign national population in your workforce, you may be familiar with the H-1B visa. It is a rather common visa type. The H-1B visa is the specialty occupation visa. That means that the position requires at least a bachelor's degree in specific fields of study for performance in the role. It is valid for 3-year periods. The maximum is 6 years of H-1B status in the United States. However, very importantly, H-1Bs can be extended beyond that 6-year maximum when the employee is sponsored by the employer in the green card process. The H-1B is subject to a lottery system. There are 85,000 H-1Bs available per year. And for the past many years in a row, there have been more H-1B petitions filed than there are those 85,000 spots. So in turn, there is a lottery selection, a random lottery selection process that occurs, and that is going on right now. H-1Bs are filed in the first week of April, with first employment on the new visa starting on October 1st each year. You may also have the opportunity to transfer a candidate's H-1B visa to your company. That's also very common. So if a person has held H-1B in the last 6 years in the United States, then you do not need to pursue the H-1B through the lottery process and can instead directly transfer the H-1B to your company. So again, H-1B is a very common option if you find a foreign worker who you would like to hire. Other options include the L-1 visa. The L-1 is the intra-company transfer visa. So if you have entities outside of the United States that share common ownership with your company, if an employee has worked with that entity for 1 continuous year out of the last 3, you can assess for transfer on the L-1. The L-1 has 2 subsets. It is the L-1A manager or executive. That is self-explanatory. It is what it sounds like for managers or executives. There is also the L-1B. The L-1B is for specialized knowledge, and specialized knowledge is knowledge of your company products, processes, technology, methodologies that is unique or advanced when compared to the individual's peers. So this visa type, the L-1B, has more discretion in terms of whether a person qualifies. Do they, in fact, have advanced or unique knowledge? But it is, again, an option to you if you have a company abroad and have identified a worker there who you'd like to transfer to the United States. In terms of validity, the L-1A allows 7 years in the United States maximum. The L-1B allows 5 years in the United States maximum. They are first issued for a 3-year period. Then there's a 2-year extension for a total of 5 years. The L1B then is at its maximum period, but the L1A is then eligible for another 2-year extension for a total of 7 years. A further visa type that could be an option is the TN visa. That is the NAFTA visa for citizens of Mexico or Canada. It is limited to specific enumerated occupational categories in the regulation. Common occupations that employers sponsor on the TN are an accountant and an engineer. TNs can be issued for 3-year validity periods, and they can be extended indefinitely, so long as you choose to continue sponsoring the individual for the TN visa. Another common visa that employers use initially in employment relationships is the F1 OPT. That is a student who has graduated and now has work authorization on account of attending a U.S. university. It's a requirement that the work you sponsor them for is sufficiently related to their degree of study. Initial OPT is 1 year in length, and if the student earned a degree in a STEM field, science, technology, engineering, math, they are likely eligible for a 2-year additional extension of OPT for a total of 3 years. So I mentioned the H-1B before. It is very common to see an employee initially brought on to the employer under F-1 OPT and then be sponsored for the H-1B lottery system. Again, we just completed H-1B lottery work about a month ago now, and F-1 to H-1B is very common. Lastly, a visa option is the O-1. The O-1 is for persons of extraordinary ability. There are enumerated criteria we use to qualify a person as a person of extraordinary ability. It is commonly that they have published in their field of expertise, they might have patents awarded to them, and they likely have won awards for their work. So it's an option that we look into if the person is very sophisticated in the role, or if we can't quite find anything else that works. So we look into, do we have the possibility of positioning this person as a person of extraordinary ability? This visa validity is 3 years initially, and then can be extended for 1 year extensions indefinitely as well, as long as your need and desire to sponsor them continues. So those are common visa types that you would use to initially bring the employee to your company and sponsor them for work authorization. When we look forward to the green card, the green card is very beneficial to your employing this individual and their living and working in the United States because it is permanent. It allows a person to live and work permanently in the United States. So when a person is granted a green card, they will be a permanent resident so long as they want to, unless it is taken away, which is in more extreme circumstances. The actual green card itself is going to have 10 years validity, but that expiration date refers only to the card. They need to renew a green card every 10 years for security purposes, to ensure the photograph that is on the card still somewhat resembles them. But again, that expiration date does not relate to the permanent resident status. It simply relates to the card. So again, This presentation is a broad overview of the path to citizenship that an employee would experience. So please know that there are many different green card eligibility categories. We are going to simplify it significantly and focus only on green card sponsorship through employment. So what does that process look like? Green card sponsorship through employment. And to reiterate, this is a very simple slide for a complex and lengthy process. For some individuals, this slide will take about maybe 10 to 12 years. So again, this is very simplified. So to start sponsorship on a green card as the employer, you're going to have to initiate sponsorship. So that is going to include filing an immigrant petition. There are some green card categories that can start directly at the immigrant petition. These are commonly the multinational manager or executive green card or the extraordinary ability green card. So in those categories, we start directly at the immigrant petition. In the more common scenario, before we get to the immigrant petition, we have to first satisfy the Department of Labor that we have tested the labor market and not found a qualified and willing U.S. worker for the role. So if you're familiar with green card sponsorship, or you find yourself starting the process for a worker, you may not be able to jump right into the immigrant petition and instead need to go through the stages with the Department of Labor. But once the immigrant petition is filed, the date that U.S. Citizenship and Immigration Services receives the application becomes known as the employee's priority date. And the priority date is the individual's place in line to wait to proceed to the final stage of the process, which is filing for the actual green card. Now, when I started this slide, I said for some people, this one slide takes 10 to 12 years. And that wait is applied at this stage. When the immigrant petition is approved, some people are in a category. Those categories are commonly persons born in India or China that are many years in length to wait to proceed to the final stage of the green card. Right now, persons born in India in the EB2 and EB3 green card categories are waiting, unfortunately, 10 to 12 years to proceed to the final stage of the green card. Other persons, for example, if you have an employee who is in the EB2 or EB3 category and born in Denmark, that individual can actually file the individual green card application concurrently with the immigrant petition because there is not a backlog in that category. To note, the reason that there is a backlog in some country categories and not in others is because the Department of State allots a certain number of green cards to certain categories. And as I said, India and China are oversubscribed. There are more people that have applied in those categories than there are green cards available. So it creates the line and this wait. So once an individual gets to the front of the line and can file their individual application for a green card, they can do so with U.S. Citizenship and Immigration Services, or if they happen to be outside of the United States, can also pursue the green card that way through the U.S. Department of State. The process includes a biometrics appointment at the local USCIS office. That's for fingerprinting, photo, and a signature for background checks and clearances. The process will also include an interview at the local USCIS office. At that interview, the officer will go over the application packet, including specific questions on admissibility. For example, have you ever committed a crime? The officer will also go over basic biographic questions and questions about the employment sponsorship. For example, who is your employer? What is your position? Where do you work? So the interview did not used to be required. However, the Trump administration implemented a policy that now requires all employment-based green card applicants to attend an interview. So post-interview, the decision will be issued. That could be a request for evidence. Hopefully not. Hopefully it's simply a approval. And then the individual will receive his or her green card in the mail. So for many, I'll say all people, when that green card arrives in the mail, that is a thrilling day. Really exciting to note. As for employers, at that time you would re-verify their I-9 with their green card, and thereafter no longer need to do so. So some benefits of the green card to the employee. First, and likely most important, a green card holder no longer needs to continue renewing non-immigrant status. So if the employee was on H-1B, H-1B extensions are no longer needed. So that is a great benefit to the employee in terms of stability for their life in the United States, and also a great benefit to you as the employer, because you can stop paying for those extension applications. Additional benefits to a green card: the employee can work in any employment capacity in the United States. They could also choose to not work if that is their preference. The green card holder can start a business. They can qualify for financial aid and in-state tuition. So when the employee receives a green card, the dependent family members who qualify will as well. So if the individual has children who later will become of university age and will attend, it's a great benefit to qualify for financial aid and in-state tuition. A green card holder can also qualify for Social Security benefits after 10 years of work. And if there is what we call a later, an after acquired spouse or child, meaning after the green card is issued, then the employee can sponsor those family members for green cards. So all great benefits to the employee. And as I said, not extending that H-1B, for example, or the L-1, whatever the non-immigrant status is also a great benefit to you as the employer.
Mm-hmm. So Anne, so that's a great explanation right now, from the employment-based visa to the green card. So before I move on to the next slide, just to show that I had some stats about the green card, quick question. You mentioned the various categories, and you brought up India. If someone wanted to know how long does the green card take for a particular country, he or she can find it. How can he or she find that out? The visa bulletin, or is there another way?
Right. Correct. So each month, the Department of State publishes the visa bulletin. It is publicly accessible. Simply search visa bulletin, and there you will see the various green card categories with the lines. And the way to look at the visa bulletin and understand it, you will see listed dates under each category. Those are priority dates. And it means that in order to file the I-485 application, the individual application for the green card, the employee needs a priority date that matches the date listed or that is earlier. So yes, absolutely, visa bulletin is publicly accessible. Anyone can look to it to assess how long the line will be, the wait will be for their employee to get to the final stage of the green card process.
Gotcha. Thank you. So Anne, you just talked about this slide here, the benefits of a green card, and I think it transitions really well into the stat that we found also from our trends report. Nearly 66% of companies that were surveyed sponsor a foreign national for permanent residence. I think, now that more than ever, foreign national employees are looking for that peace of mind and security associated with the long-term sponsorship. The path to permanent residence is a powerful incentive. And then moving along here, so of the 66% of companies that do sponsor, 66% do so within the first year of service. And then you see here on 28%, 3 years, which, and as you mentioned, the H-1B visa renewal, and then 3% after 5 years of service. And I have another question for you. Let me pull it up here. So as we see here, 66% of companies that sponsor do so within the first year of service. Why might companies sponsor within the first year? Does this help with the employee experience in some ways, or anything else?
I think certainly for attracting candidates, employers offer green card sponsorship within the first year. Certainly in areas of the country where there is a lot of competition for certain types of talent, we see employers starting the green card process within the first year or even immediately upon hire. So as an incentive, or as you said, as a tool to attract candidates, green card sponsorship is used. I think also it is used within the first year for stability's sake. As soon as the employer identifies the employee has good performance and that this is a relationship that they want to continue long term, for stability's sake, they go ahead and get the process started, because they know that once they get the green card, they get to stop extending the non-immigrant status. They know that extending the non-immigrant status could include responding to requests for evidence in this immigration climate. So again, from a stability standpoint, once they identify that it's a relationship they want to continue long term, then they go ahead and get the green card process started. Gotcha.
Okay. And then one more stat that I think I would just want to bring up here on this slide is what green card costs do companies typically pay for? We're not going to go into too much detail here, but just I thought it was worth highlighting. In 2019, 49% pay for all green card related fees with the contractual stipulation, and then see here it's broken down, 31% pay for all green card related fees. So it just breaks down some of the fees that companies are paying for, which I think is very, very interesting as we talk about this particular topic. And as always, and I'm sure you're well aware too, that technology can play an important role in the green card process. With technology, you can accurately manage and forecast green card eligibility for your entire workforce. So it could take some of the guesswork out of this particular process. All right, so Anne, I think that wraps up the green card section. So what can you tell us about the next one, the next step of this process, U.S. citizenship through naturalization?
Sure. So for many employees, the steps and the wait to get to applying for naturalization is long. And so once they get here, it is frequently the goal to go ahead and become a U.S. citizen. From their perspective, becoming a U.S. citizen allows them important rights, like the right to vote, which they might find incredibly important to their interests and their civic participation. It also could allow them, more stability within their status. They no longer need to continue every 10 years renewing the green card, and can instead live and work in the U.S. as a U.S. citizen. Once they are a U.S. citizen, they could also choose not to live in the U.S. for a while, as long as they'd like, with no fear of losing their green card and permanent resident status. So those are a couple of reasons why an employee may have interest in obtaining U.S. Citizenship. From the employer's perspective, in terms of encouraging employees to pursue citizenship, two benefits are you can place a U.S. citizen on U.S. government contracts if you participate in that type of work, whereas you may not be able to place a permanent resident on all of those U.S. Government contract options. And second, you can place a U.S. citizen on an assignment abroad without fear of impacting his or her rights to return to the U.S. to live and work. The green card is permanent, but as I touched on very briefly, it is possible to still lose it. And one way to lose a green card is by spending too much time outside of the United States. When a person is issued a green card, it's a requirement that they intend the United States to be their permanent home. So too much time outside of the United States can put a green card at risk or actually void the green card. So when you have an employee who becomes a U.S. citizen, then there's no longer a concern that placing him or her on an assignment abroad will impact the right to return to the United States. So continuing on, how does someone become a citizen? So there is a length of time required to be a permanent resident before a person can apply for citizenship. For an employee receiving a green card through employment sponsorship, that period will be 5 years. There's an exception to the 5 years for persons married to U.S. citizens, and it is only a 3-year period. But in your practice, I expect you'll mostly work with individuals who need 5 years of permanent residence. So in addition to those 5 years, they must meet certain eligibility requirements. Those include being at least 18 years old at the time of filing. I think that for your employees, you'll find that is nearly a given. There is the U.S. physical presence requirement that is exactly as it sounds. And the rule is that for the 60-month qualifying period, the employee must have spent 30 of those months within the United States. There's also a U.S. continuous residence requirement, and that relates to not having an absence from the United States that is too long. Again, as I said, when a person is issued a green card, he or she must intend the United States to be his or her permanent home. So this U.S. continuous residence requirement relates to that. And a person to demonstrate U.S. continuous residence does not want an absence of longer than, a single absence of longer than 6 months to demonstrate continuous residence. Additionally, to become a citizen, a person needs to be able to sufficiently read, write, and speak basic English. There's an exception to that based on age and length of time having lived in the United States, not likely to apply to your employees. Additionally, a requirement to pass a U.S. civics test, and Eric is going to do a fun exercise of asking some of those questions, because you might be surprised that you don't know. I do not know some of the answers. So that is a requirement. It's really, it's not a scary test when a person knows that it's coming and reviews the material. There are 100 possible questions that can be asked. The answers are provided, and the individual will be given the option, 10 questions and must get at least 6 correct. So they will know what the questions will be and also what the answers are. Lastly, to qualify, a person must be of good moral character. That is a specific legal term, and it relates to no criminal history that makes them inadmissible to be a citizen or other matters. So certainly an attorney is useful if there are any questions as to potential difficulties with criminal history or other matters related to good moral character. So in terms of the actual application, it's called Form N-400, Application for Naturalization. The form itself is lengthy. It is 20 pages long. But for the most part, the information required is not difficult to provide. Form information that is required includes last 5 years residence addresses, last 5 years employment information, including job titles, employer name, employer addresses. The form requires all trips outside of the U.S. in the last 5 years. So for persons who have traveled frequently, the requirement to list all of their trips can be burdensome. It's a good idea when a person becomes a green card holder and has interest in applying for citizenship to go ahead and proactively start a travel log, knowing that on the citizenship application, he or she will need to list all of that travel, because trying to look back and pull that information can be difficult. And additionally, information required includes prior spouse information, and any children's information. In terms of documents, if you have experience in immigration petitions, frequently they're very document heavy. The citizenship application is not, from my perspective. It requires the check, of course, photocopy of a green card. If the individual's name has changed since receiving the green card, for example, through marriage, that name change document is required. If the person has ever been married before and is no longer, marriage termination documents are required. And this list is not all that could be potentially possible. If there is criminal history, documents related to that will be required. So of course, each individual needs to check into their own specific situation, but that's an overview of the citizenship application. So typically long form, but documents are normally minimal.
Gotcha. So yeah, Ann, actually you teed up this next section really great. Let me switch the slide here. So there was an interesting article that was forwarded my way from a colleague of mine that found the Woodrow Wilson Foundation found that only one state can pass the U.S. citizenship exam, which, Ann, as you mentioned, is part of the citizenship process. So the link to that, to this finding is below. You can click that. But I did want to run a fun exercise for our audience. So I'm going to pull up 3 sample questions from the citizenship exam. They're available from the USCIS test prep. So if everyone takes a look at their screen, we'll start with the first one here. Whoops, let's see here. All right, so when was the Constitution written? Give everyone a few more seconds. All right, and close this poll. Let's see here. So it looks like 67% of responses said 1776, 18% said 1787, and 15% said 1789. No one voted for 1790. So the answer is 1787. So 18% of respondents got this answer correct. Let me pull up our second poll. Here we have what are two cabinet level positions. We have Secretary of the Interior and Secretary of History, Secretary of State and Secretary of Labor, Secretary of Health and Human Services, and Secretary of the Navy. Had to abbreviate that one because the characters limits. And then Secretary of the Weather and Secretary of Energy. All right, close that one. All right, yeah. So 3% voted for answer A, which was Secretary of the Interior and Secretary of History. 90% voted for Secretary of State and Secretary of Labor, and that is the correct answer. And our final question here. Let's launch this one. So the idea of self-government is in the first three words of the Constitution. What are these words? All right, I'm gonna close this one here. All right, so we have we the people, we the colonists, Congress shall make, or we the British. 98% voted for we the people, and that is the correct answer. So thanks everyone for participating in these three questions, but it just goes to show that, I mean, some questions that we take for granted, you know, are a little bit more difficult. I know when I first did it, I actually got the Constitution one wrong. So yeah. And I know we're getting close to our time, so I'm just gonna forward this. We'll kind of wrap things up here. So Anne, do you want to take it away?
Sure. So post-interview, USCIS is going to send a decision on the naturalization application. If approved, then a notice to take the oath of allegiance will be issued. The individual will attend the oath of allegiance. At that appointment, he or she will turn in the green card and receive the citizenship certificate. And it's not till they receive that citizenship certificate that they are actually U.S. citizens. But those are, I know I've attended some oath of allegiance ceremonies, and those are great events and very happy days. So in terms of just one more slide, just that, you know, for interest, this is the oath of allegiance. It does include language that relates to, you know, renouncing allegiance to, you know, other foreign states or sovereigns. So whenever an individual is applying for citizenship, he or she needs to consider if the country of prior citizenship allows them to be a dual citizen, because it could be possible that no, that it's not. So that's an important consideration. But we simply thought that this oath of allegiance was interesting with some of the language. For example, you know, continuing the obligation to agree to bear arms on behalf of the United States when required by law, perform non-combatant service in the armed forces when required by law. So we found that interesting.
Mm-hmm. Yeah, definitely. I mean, especially, I mean, and from my perspective, just because, I mean, this isn't really something that I've had to look for. So, you know, the first time I read it in depth was, you know, actually just researching for this presentation. So I agree, it was super interesting.
Mm-hmm.
So that brings us to the end of the presentation, and we're right at the 1:45 mark. I'm just going to go quickly through some end of presentation housekeeping items. We got some great questions rolling in, so keep these coming in. Just a quick note: some of them are a little specific. Unfortunately, you can't answer these over the line. So either reach out privately or consult with your immigration attorney for those. So just quickly, got a couple May webinars coming up. These are on our website that you can sign up for. keep this open here. GTS, our private, our events, encourage everyone to sign up here. Apologies if I'm rushing through this, but I do want to get to a couple questions. The one slide I am going to leave up, though, is this one right here. Everyone in attendance can copy down the continuing education credits for SHRM and HRCI. These will also be made available in tomorrow's follow-up email. So please take a moment to copy those down. So Anne, so a question for you. So we just did a brief example of the civics test. Obviously that's part of the citizenship process. When does the civics test actually occur?
So the civics test occurs during the naturalization interview with the U.S. Citizenship and Immigration Services officer. So certainly the applicant will have sufficient notice to prepare for that civics test. The notice should come a few weeks before the requirement to attend. So the applicant will have time to prepare.
Gotcha. Let's see if anyone has any questions. Send those in now. Otherwise, just wait a couple seconds. Okay. And thank you so much for this walkthrough from employment-based visa to citizenship. I found this really, really interesting, and I think it's really helpful to see the entire process from an overview. For everyone currently listening in, thank you so much for joining us. Hope you enjoyed that little poll. See a couple of sample questions. Again, this recording and the slide deck will be emailed out tomorrow, so please keep an eye out on your email inboxes for that. And with that, thank you for joining us. Have a good rest of your day, and have a good weekend.